All rise.
Mr. Alatek.
My Lords, if I can start with my Lord Justice Arnold's question to me that I wasn't able to answer before the short adjournment, positively the question of jurisdiction and what would happen if the German court declined jurisdiction.
Could you be very, very kind to me and keep your voice up just one notch higher?
Certainly, my Lord. Sorry, I think it's faded after the morning. On jurisdiction, the first point to make is that it's the enforcement court that had an issue with jurisdiction on the basis that there was no intention to enforce in Germany. That's why it declined jurisdiction, and the Court of Appeal of Ham accepted jurisdiction on the possibility of jurisdiction in Germany. Now that's just a clarification. It's never been suggested that the trial court, which is seized of the application under section 767, would decline jurisdiction. But assume.
Sorry, I'm a little puzzled because I understand the distinction that is drawn in that regard by the BGH in its judgment. I'm unclear as to how you say that maps onto the proceedings in Germany in the instant case.
I think in the first case, Mr. Windhorst applied for a stay of enforcement of the judgment in the procedural court, and there was an issue.
I'm baffled by your use of the word procedural court. What on earth do you mean by that?
I'm simply abiding by the terminology that I've become familiar with, and I mean the Court of Bielefeld and then the Court of Ham. That's what I mean.
But the Ham court is just an appeal court.
Yes, and when I use procedural, I'm really talking about the jurisdiction they're exercising. It's an application under the ZPO, so the civil
yes,
procedural.
But that's not that specifies the procedure, but it's still a substantive application.
I understand that it's an application to stay the enforceability of the order, and I understand in that sense that it could be described as substantive, but it's not substantive in contrast to the claim and the rights compromised by the composition. Now, what I was going to say, my Lord, is that assume that the German court refuses to entertain the dispute as to whether or not the composition is effective because of voluntary payments, because it says it has no jurisdiction to do so, because jurisdiction is in England, not in Germany. So assume that.
Yes.
Assume that, and in that case, the composition would still stand, because if the German court has declined jurisdiction, there is no decision with respect to the composition. Now, my Lord's question is, well, someone must decide the argument, so who? And our answer is that the English court, being a court concerned with execution of the German judgment, would refuse execution because of the composition standing. It would not have to decide whether Mr. Levy's rights have revived and they've become perfect again because of voluntary payments. That's a new claim. The English court would not, on an application for a charging order, for a stay of execution, as in this case, have to decide that question. What it would do, it would refuse execution or grant a stay because of the composition. And Mr. Levy, if he wished to pursue the case that by reason of voluntary payments, post-composition, the imperfect obligation had become perfect again, he would plead those facts as a cause of action, and he could pursue that cause of action as a civil and commercial claim. It would not be right in the execution court to have that debate ex hypothesi if the German court refused jurisdiction. It would just be an odd way of proceeding to decide what is in a sense a fresh claim based on past events at the stage of execution on the judgment that had been compromised by a composition.
Sorry, I'm not clear. If Mr. Levy wanted to contest that, you say he'd plead that as a civil and commercial claim. Where would he do that?
Well, you could do it wherever you could take jurisdiction. I mean, the EU judgment regulation may well apply. I mean, we're now out of the EU. But he could do it where Mr. Windhorst had his residence, assuming. I mean, domicile would be the old rule.
So you say it would be treated as an entirely new claim and you'd apply ordinary
what I understand,
principle.
and I may be guessing, but what I understand my Lord's concern to be is that if the German court decides jurisdiction, declines jurisdiction, is the executing court going to be burdened with a problem that is too difficult for it to solve? And in testing my submissions, is that a way to test those submissions to be unsatisfactory? And my answer is, if there's no judgment in Germany as to the effect of the composition, because the German court declines jurisdiction for whatever reason, the composition stands. If Mr. Levy wants to then pursue a case that he still has a valid in personam right against Mr. Windhorst because of voluntary payments made post-composition, that is a new claim. So there's going to be no stifling of the claim. There's going to be no denial of access to justice. What there won't be is a very unusual circumstance in which a court, which is meant to be dealing with the execution of a judgment, ends up trying out the merits of a cause of action.
At the same time, it's not such a problem here because there is only one court. Whether you address the problem on this hypothesis as an execution stage or in a new cause of action, it's the same personnel who have to decide it. I mean, I say that you could consider whether it should be determined by a master or a judge or whatever, but it's all within the same system. There's no divide between a trial court and
No, and I'm sorry if I've irritated the court with my use of terminology trial court and procedural court. The difference...
Sorry, that's a different use of terminology again. So can we try and get straight what you're talking about? So we see that there's a distinction drawn by the BGH between what they call the trial court and what they call the enforcement court. Now, we can debate what that means, if need be, but it certainly doesn't use the expression procedural court or procedural claim.
No. It doesn't.
That seems to be coinage of your own, the derivation of which is obscure to me.
I rely on the evidence that I've shown you. The BJ draws a distinction between, and we can turn up the judgment again in a moment if it would assist, between the residual debt discharge, which is its translation of the discharge of debts in a bankruptcy, which it said must be pursued by way of a counterclaim in what it calls the trial court.
Yes.
Now, forget for a moment the terminology enforcement court, trial court. It could seem it's all taking place in the same court. The important distinction is between substantive rights, which in this case is the in personam obligation to pay €2 million, and the discharge of that substantive right in a bankruptcy, because the discharge of bankruptcy is a privilege. It's a substantive right given to him to deal with his debts. So those are two substantive rights. What's happened in this case isn't a bankruptcy, it's a composition, which is a source of rights, and that source of right compromised the in personam obligation to pay €2 million for 1.9% of its value. And it's that distinction that I rely on in the Bundesgerichtshof judgment, because what they say is that the residual debt discharge does not impeach the enforcement order. They talk about the enforceability of titles. That's the minority opinion, which is that...
Yeah, all right, but we seem to be getting very, very confused at this stage between procedural questions and substantive questions. Now, let me try this one on you and see whether you agree with it or disagree with it. Would you agree that the reason why Bundesgerichtshof made the distinction between trial court and enforcement court is because in that they were looking at a context where you have got actually, I think that's the suggestion I was about to make doesn't make any sense either. But the question of which court has jurisdiction is a separate question, is it not, from the question of what needs to be done in order to enforce a judgment debt in circumstances where there's been a subsequent insolvency plan. Because you can't, what they are very clear about is that you've got to proceed under section 767.
Yes, that's what the ratio of the case is. They say you can't put a notice, a reminder, against enforcement. You must apply under 767, and that's because the reorganisation of the claim gives rise to a substantive obligation under substantive law. Now, ignore the rest of the sentence in paragraph 11, which is can only be pursued by a counterclaim or enforcement. That's the procedure by which you enforce that substantive right. The important point for present purposes, my lord, is that on ground 1, I'm seeking a stay of execution on the basis that the composition is a source of substantive rights which satisfies the in personam obligation. And to that essential point, the differences between procedural court, enforcement court are unimportant. And so what I was positing, my lord, is in a situation where the German court refuses jurisdiction because it doesn't want to decide the question of substantive rights because enforcement is in England, not in Germany, the English court is left with a composition which is a source of substantive rights, which Mr. Windhorst can, and I say does, rely on in support of a stay of execution. And it doesn't require the English court to assume the burden of deciding for itself a complex question of German law. It gives effect to the composition, which should have effect without further formality. And that's not to stifle the claim. If Mr. Levy wishes to pursue it, he can pursue it as a fresh claim.
But then the implication of that, if I've understood it correctly, is that if the fresh claim, as you put it, was successful, there would be a fresh judgment and a fresh application to register that new judgment.
Yes, and that new claim would be successful on the basis that it's been pleaded and held in a judgment that the nature of the, as at this time, disputed voluntary payments, as a matter of fact and law, calls the obligation to revive, such that there's an in personam debt which Mr. Levy is entitled to sue on and is entitled to retain judgment. At the moment, what we have is a judgment, and I was going to take you to paragraph 44 of my learned friend skeleton, which I thought put the point very fairly, which is enforceable, quote, in German procedural law. It's not said in the evidence or anywhere in the submissions that the judgment is enforceable other than, quote, in German procedural law. It's not, the case is not made that it's substantively enforceable. The highest it's put is that there's a dispute as to the revival of the imperfect obligation because of the voluntary payments.
As things stand at the moment, it satisfies the perimeter tests for being enforceable in the sense used in the judgment regulation.
Yes, I would accept that. Subject to grounds 2 and 3 where I challenge that. On ground 1, I accept that the judgment is enforceable, should be registered in the UK, but under the CPR 83, I invite the court to stay execution for the reasons I've given.
Okay, I realise I've got myself muddled. I think I once knew the answer, but I'm not exactly clear how the German judgments relate to each other. Can we just run through them?
Yes.
111 is Bielefeld District Court.
Yes. Can I just... If we go through them quickly, paragraph 17 is the 2003 judgment. Page 17 of the supplemental manual is the 2003.
Yes.
That's
Can we jump to the recent German decisions?
Yes.
I'm clear about the earlier ones. It's just a recent one.
So if we go to page 101, this is dated the 26th of June 2019. 11. Sorry.
111, yes.
This is, I think, the first of the recent judgments.
Yes.
This is Mr. Windhorst, he's the applicant here. He's seeking the injunction to restrain action on the 2003 judgment.
Yes.
And on this judgment, the judge does award a temporary injunction. He would suspend the enforceability of the judgment pending the payment of security.
Yes.
And that's an injunction. But when one gets to the, I suppose, a return date on the 6th of November, page 122.
Yes.
The judge refuses jurisdiction. It doesn't deal with anything beyond jurisdiction. And at page 125, it says that this action is inadmissible because the court has no international jurisdiction. And the reasoning begins with Article 22 of the Judgments Regulation. And I said earlier that I thought this was unusual.
So we're back to 22.5.
Well, it's because it's an intra-German judgment. It's a German court looking at a German judgment. So it seems a little unusual that you're looking at community legislation. But
I don't know. If you're under European law, the question of execution is allocated to a different
I think
court.
that must be the reason for it. I'm not being in any way critical of it.
No.
Just as an outsider looking in, it did strike me as initially unusual. But be that as it may, they do apply a test of international jurisdiction even when looking at their own
Yes.
judgments. And it said that because Mr. Levy is not seeking execution in Germany, the court has no jurisdiction.
Yes.
And then you get the Court of Appeal in Ham, at page 177. Basically, the reasons are at page 178, which does stay the enforcement upon the condition of security. And it does so because it says there's a possibility of enforcement in Germany. It says that there are statements made, in particular in the letter of the 17th of April, which indicate the possibility of enforcement in the UK and elsewhere.
Yes.
So that's all the German courts have decided in this case.
And sorry, I'm getting myself confused. What's 204?
204 is
Is it the same thing? No, it's a different thing. And here it says the German courts are likely to have international jurisdiction.
It looks like it's an application for interim relief. And so paragraph one, it maintains its preliminary assessment of admissibility, so it affirms its previous judgment.
And we see there's reference to the applicant's request of the 20th of March for amendment of the decision of the 19th of February, and that's rejected. In fact, both sides' applications for amendments are rejected. So this is, so to speak, a revisiting of the previous Court of Appeal order. So
It looks like it's a form of review jurisdiction of some sort.
yes.
And as we updated the court this morning, the application under section 267 is coming on in January.
Yes. And this, to be clear, would be proceedings started in the trial court and taken on appeal to the Court of Appeal in Ham.
It's in line with the Bundesgerichtshof
Yes.
decision. So it's that court that will decide substantive rights, essentially the dispute as to whether or not the obligations have revived. And that's one of the points we say argues for a stay of execution, because unless and until that's decided, it would be unjust for the effect of the composition to be denied and for execution to be levied.
Yes.
My Lords, before I move on to the grounds, I had one other point from this morning, which was a cross-reference in Article 25. My Lord is right, it is basically add 7, but there's a slight care that has to be taken with what was Article 34 of the Brussels Convention, which has 3 subparagraphs. That doesn't equate directly into add 7, because that doesn't take one to the right paragraphs. What's happened is paragraph 34.2, I think, is Article 45.1.
I see.
And that is the article that Article 25 of the Insolvency Regulation doesn't apply. It doesn't say anything about Article 34.3 of the Brussels Convention, which is the rule that one does not review judgments as to their substance. And just for completeness, Article 34.1 of the Brussels Convention is Article 41 of the Judgments Regulation. We haven't got a copy of the Brussels Convention in court, but I've asked for copies to be made available.
And just before we move away from the German judgments, if we take, say, the I don't know, take, say, 177, the first Court of Appeal decision.
Yes.
Which provides for enforcement to be suspended against security.
Yes.
And we see, looking at 178, little b, the court says setting up, staying presumably without provision of security, without the questions, the requirements of 7691. Sentence 2, ZPO have not been demonstrated. Just taking out of course a moment longer, if under German law the requirements for a stay without security have not been demonstrated, as I understand it, because you're not suggesting that you haven't got the money, why should this court take a different position?
That is because the German court is looking at an application to stay the formal enforceability of the order that's final and binding nature, which is a different question to this court as an execution court. They are looking at different questions, and it's the duty of each national court to apply, in this case, the insolvency regulation in accordance with its national law. And so the English court is required, we say, under the CPR, to have regard to the insolvency regulation and stay. What the German court has done is something different. It has declined to set aside the formal enforceability of the order, pending an application under 267, and if an interim stay is required to set aside that formal enforceability, it requires security. So that the decisions aren't mirror images of one another, and each court has its own obligations, in this case to give effect to the insolvency regulation. So that's my answer as to why this court should not feel bound to do as the German court. And my learned friend's right to say that's why my case on stay is put on the basis of an obligation under the insolvency regulation, because it's quite right to say that we didn't even run a hardship ground because we could pay the security. But obviously, if you want a forensic answer, it's quite a lot of money, and better use can be made of that money if we are not, as a matter of right, required to pay it.
Yeah.
My Lords, we covered much of the grounds 1, 2 and 3 this morning. I wanted to say very little about ground 1. As for my part, the questions for my Lord have essentially explored the essential points I would make. I'd remind you of paragraph 44 of my learned friend skeleton. It's one reference among many, where it's very fairly said that the judgment is enforceable in German procedural law. That's the quotation, and there are others like it. It's nowhere said that the in personam obligation has not been compromised by the composition. That's, as it were, the sheet anchor of my case on ground 1. And in a nutshell, we say the judge made a mistake in paragraph 66 of her ladyship's judgment when she took her conclusion on formal enforceability, which she'd reached earlier in the judgment, and rolled it forward into the CPR context. In other words, the judge's judgment could be entirely unimpeachable on the refusal of the appeal against registration and for the reasons which she gave, but we would still have our case as for a stay under the CPR. On ground 3, I have very little, in fact nothing more to say on ground 3. I've explained that the reason I've developed a European-wide answer in the form of ground 3 is to deal with the constraints of Articles 34 and 35 plus 45. So I've made an argument based on the meaning of enforceability, and I've sought to follow the Advocate General, who has put the point as I would put it. And so I can't really develop that argument much further. I was going to develop ground 2, which gives analytically a different answer to the same end, which is that when one's dealing with qualifications and perimeter questions, you can still take those without an affront to the wording of Article 34, 35 plus 45. The essential argument is the one I've already made, which is if you take questions, is this an arbitration award? Is this even judgment? Is it a civil and commercial matter? Those are outwith the scope of the judgment regulation. So there's no affront to the language of the provisions within that regulation. I want to show you briefly the academic commentaries that speak with one voice on this matter.
Well, you've given us the references, haven't you?
I have.
They're the last 5
I don't need to
tabs of the bundle.
I can give them to you right now.
Well, they're all highlighted in the last 5 tabs of the bundle.
My lords, in that case, all I would say is that I like the way it's put by all of them, but in particular, I thought the expression in Fawcett's work was particularly useful.
Sorry, which one?
Fawcett, it's the Cheshire
Yes,
North book. Professor Fawcett has said that the elegant submission that enforcement presupposes recognition, and thus there is a means to reconcile the literal wording of Article 45 with the ability to dispute matters not within Articles 34 and 35. I would also adopt the way Professor Briggs puts it in all his works. I'm not actually sure who writes Dicey, or I think it's a combination of Professor Briggs and Lord Collins. But the point they made, and you've got the references, is they go through each of the sub-paragraphs of the regulation that isn't in Article 34 and 35, 49.1, 67, 71, and they say, well, what about this? And the way the argument is developed is that you have perimeter questions, which are essentially as to the material scope of the regulation. The way you've got a conflict, it's not a positive expression of material scope, like civil or commercial matter. It's a negative definition. And where there's a conflict with other community legislation, that should be a point that one can take. And test it in this way, if I may. What effect does the composition have in this case? If not the effect to prevent a stay of execution, what effect is this court allowing it to have? Because if it's accepting that merely raising a dispute as to post-composition events can nullify the effect of a composition, then that does serious damage to the utility of the insolvency regulation and the judgments that emanate from it. One cannot, we know in the civil and commercial world, simply raise a dispute post-judgment as to the merits to deny effect to a judgment. That's not permitted. And rhetorically, we say the same should not be permitted with respect to a judgment in insolvency. That's what I wanted to say on my grounds, my lords. Are there other questions that I've not satisfactorily addressed?
Thank you very much, Mr. Arthur. Ms. Vannegut.
My lords, my learned friend has addressed you on the background, so what I would propose to do is to go for each ground of appeal in turn and address some of Mr. Alatar's points as I go along. So the first ground is that it's being said on behalf of Mr. Windhorst that the court was obliged to order a stay of execution in order to recognise the insolvency plan under the insolvency regulation. Our answer to that, in short, has three limbs. The first one being that under the insolvency regulation, all this court has to do is give the insolvency plan the same effect here that it has in Germany. Then secondly, we'll go take another look at the BGH decision, which shows that in German law, the enforceability of the 2003 judgment is preserved despite the insolvency plan until a successful application under section 767 is made. And thirdly, I will address the English court's jurisdiction to grant a stay of execution and why we say that the insolvency plan or insolvency regulation don't affect that. I realise there's a certain overlap between ground 1 and ground 3. The way I would propose to deal with it is to focus on German law and on the insolvency regulation when I address you on ground 1, and to focus on the European case law when I address you on grounds 2 and 3. Now, the first point, what does the insolvency regulation actually say? A lot of this can obviously be cut short because Mr. Alatar has already given you many of its main provisions, as well as the history behind it, which was that there are big differences between the different member states' insolvency regimes. And that's why it originally wasn't as easy to come up with a harmonized insolvency regulation as it was to create one on judgments. Then I would like in particular to draw your attention to Article 4, 2J and K, which is on page 8 of the authorities bundle. That tells us that the law of the state of the opening of proceedings, here German law, governs the effects of closure of insolvency proceedings and also the creditor's rights after closure. Then 16 and 25, I believe Mr. Alatar has already addressed you on, but those essentially say that insolvency proceedings and related decisions have to be recognised. The main provision we rely on is Article 17.1 at page 10 of the authorities bundle. That tells us what recognition actually means. It is with no further formalities, the judgment opening the proceedings shall with no further formalities produce the same effects in any other member state as under the law of the state of the opening of proceedings. So all recognising the insolvency plan means is giving it the same effect here as it has in Germany. That takes us to the question what the actual effect is in Germany that the insolvency plan has on the judgment. And could we go back, my lords, to the supplementary...
Before we do that,
yes.
Mr. Alatar placed some emphasis on Article 25 of this regulation. What do you say about that?
Well, Article 25 also refers to recognising decisions, and we say recognise must in this context mean the same that it means in Article 17. So recognising a composition means giving it the same effect in English law that it has in German law.
Which you're about to tell us what the effect is.
Exactly, my lord, yes. If we can go to the supplementary bundle at pages 87 to 88 again, that is the decision of the Bundesgerichtshof that my learned friend took you to earlier. This was about a residual debt discharge, which is the same thing that Mr. Windhorst relies on here. He says the composition has affected a residual debt discharge and therefore an imperfect liability is created. And if we look at what is actually being said here from paragraph 9, we can see, and I'm sorry if there's any repetition with what Mr. Alatar has already said, but basically it is being emphasized here that a debtor who wants to stop enforcement or prevent enforcement in reliance on a residual debt discharge would have to do so by an application under Section 767 ZPO. We say that's not just a formal exercise, it's not just putting a stamp on something. It's obviously not just an automatic process, but it's an application that a court needs to determine. And in this case, the German courts have taken 2.5 years so far to determine that question. And there are going to be, for instance, some questions of fact, the intention behind the payments that will play into whether that application ends up being successful.
But that's a new claim, isn't it? It may be. At the moment, I don't understand your position.
Yeah.
Is your position that I understand your position is that the composition doesn't affect the enforceability within the meaning of the judgment regulation of the 2003 judgment?
Yes.
Is it your case that the composition involved a waiver and, in that sense, a composition of the debts at 1.9%?
Yes, although the argument that is being pursued in Germany, and I don't want to put English labels on it, but it seems to be a bit like an estoppel argument, saying you can no longer rely on this waiver because of the acknowledgement.
But that's your new claim.
No, so that is the defense to Mr. Windhorst's claim under Section 767. So basically, at the moment, it's enforceable in Germany, and it will stop being enforceable if Mr. Windhorst's claim under Section 767...
The 2003 judgment will stop being enforceable?
Yes, exactly.
But I'm pursuing something slightly different.
Mm-hmm.
I'm accepting for the purposes of this argument that the composition did not render the 2003 judgment unenforceable within the meaning of the regulation.
Yes.
But what is the effect of the composition in German law? Is it not what I would expect it to be, which is probably where I'm going wrong, exactly what it says, a composition of the liability, so that the under German law, he is no longer liable to pay 100%, he's liable, or was liable to pay 1.9%. Leave aside the new argument, but can I be clear about that? That is what it was effect.
My lord, we say the effect of the insolvency plan in German law at the moment is limited to one thing. It gives rise to a cause of action that Mr. Windhorst can now pursue under Section 767. But at the moment, it doesn't do anything else. It just gives rise to that cause of action.
But that suggests that the day after the composition was entered into and signed up by and made subject to a formal order, any of his creditors could have sued him for 100%.
Yes, although he might in that case have made an interim application for a stay of enforcement, as he did in Germany.
So in real terms, it might have taken another step, but the effect of it would be to preclude debtors who were originally owned, or creditors who originally owed 100%, getting more than 1.9%.
Well, I'm afraid, my lord, we don't agree with that, because at present, if he had any assets in Germany, the judgment could be enforced against him in the full amount. So the insolvency plan by itself doesn't preclude creditors from pursuing their claims.
But it couldn't, because immediately he'd say, here's the composition. End of argument.
Yes,
So what's the English court meant to do?
well, the English court should dismiss this appeal But in the first instance, we say the English court should make sure that it doesn't treat this judgment differently than the German court is currently treating it. And we know that the German court is currently treating this as enforceable. As a matter of practice, the debtor doesn't have any assets against which we can enforce in Germany, so we're not enforcing in Germany. But unless and until he pays a security, that judgment is enforceable there. So it should also be viewed as enforceable in England.
Can I ask a couple of questions? So, your defence to the 767 claim is based on subsequent events.
Yes.
So suppose the day after the insolvency plan had taken effect, you had sought to enforce in England. Would it be right to say that what you by then had as against Mr. Windhorst was an imperfect obligation?
Yes. What in that case would happen, I think, my lord, is that in Germany, Mr. Windhorst would, as quickly as possible, pursue his Section 767 application, which would presumably be dealt with very quickly because we wouldn't have any of those arguments that are currently being pursued. And there would probably have been a stay of execution without the security who is now ordered to pay. Of course, if there had been an unconditional stay of execution in Germany, then this judgment wouldn't have been enforceable in Germany and it couldn't have been registered here.
And I follow how you put it. Can I just focus on a couple of points? Is it already the case that there is an imperfect obligation in Germany the day after the plan has been approved?
We say... I don't think that can be right because you need a court to make an order under Section 767 saying the obligation is imperfect and therefore the judgment can no longer be enforced.
And then I'm going to ask you a follow-up question. Now, we know that in these proceedings, you've contended in Germany that the German court has no jurisdiction. And that's on the strength of Article 22.5 of the Judgments Regulation. So now we suppose the plan has been concluded. The next day you come to England and you say, well, we want to enforce in England. And according to you, there's no possibility of an application under 767 in Germany because there are no assets there. So there's no question of a German court ever reaching a decision. So does that mean that you can enforce unconditionally in England forever, or at least until there are some assets in Germany against which you wish to enforce?
If that decision were made in Germany, that the German courts cannot decide this question, then we agree with the appellant that that would become a question the English court would have to decide. It would also be a ground for... So if this happens right now, if, say, in a few months' time, the German courts say, actually, we don't have jurisdiction, then that would be a significant change of circumstances that would probably justify a new application for a stay on the part of the appellant. But it's obviously not the position we're in right now. The latest views the German courts have expressed were in the two EuGH judgments, which both said German courts are likely to have international jurisdiction.
But your contention in Germany is they don't.
That was the contention. It's not, the point is not being conceded, so it is still live. However, the focus of the argument is moving away from that as a result of the German courts being quite clear in how they expressed their views recently.
Well, let's suppose you're right for a moment in what you're saying in Germany. So the German court has no jurisdiction. So the plan is concluded one day. The next day you come to England and you say, well, what the English court has to do is give the plan no more status than it would have in Germany. And in Germany, no problem arises in relation to enforcement until there's an application under 767. Sadly, it's not possible for an application to be made under 767, so there's no German bar to enforcing this judgment in England. please can we have execution?
Well, that would change the shape of any application for a stay of execution in England, because at the moment, the German courts think they have jurisdiction, so we're in the 767 regime, and we have to follow that. If we're taken outside of that regime, because the German courts say that they don't have jurisdiction, then the whole shape of the case changes.
But how can you be in a stronger position while the point is pending before the German court? Because as maybe I've misunderstood even the first thing. I understand your position to be that if this court finds in your favour on this appeal, you can execute for 100% tomorrow.
Yes. So at present,
How can that be right?
well, the German courts have taken the same view. At the moment, we are entitled to enforce in Germany.
Because he hasn't paid the security.
Exactly. And that was the alternative argument before the High Court, that if the application for a stay wasn't just dismissed, then we would have sought a condition attached to it, like there is in the German courts. But in reality, at the moment, it's enforceable in Germany, and therefore it also being enforceable in England doesn't put the respondent into a better position in England than he is in Germany. It puts him in the same position.
Can I just pursue it a moment? Sorry, Richard.
Go ahead.
Can I then just pursue it one moment longer? Whether or not the German courts have jurisdiction, in a sense, isn't a question of whether they're persuaded they have jurisdiction or not. It's a question of whether Article 22.5 bites. Let's suppose that Article 22.5 bites, and then we have the only jurisdiction as the executing court. So what do we then do? Do we just say, well, the plan is effective, or do we say, well, we have to consider whether to grant relief under Article 767, or what do we do?
Well, my first submission is that this couldn't be decided in the framework of the present appeal, because that is not something the appellant is currently arguing in favour of. In my submission, the best way to deal with it would be by determining another stay application. So there would have to be a separate application and then a hearing of that application. We should make clear that where it says in the German, my lords, you've spoken a bit with my learned friend about the part of a German judgment.
Sorry, before you go back to that, can I ask the question I was going to ask, which is, you made the point that you had an alternative case before Mrs. Justice Eady, that if there was to be a stay, it should be on the basis of the same conditions as have been imposed by the German courts. Do I take it that's still your fallback position?
Yes, that remains our fallback position, although given that, I mean, obviously, primarily we are very happy with what Mrs. Justice Eady decided. But yes, our position is that it would be better to have a conditional stay with the same conditions attached to it than an absolute stay, which is what the appellant contended for.
And can I follow that. Would it be the case that there had to be some rider to it, such that if the German court declined jurisdiction, there'd have to be some way out? I mean, the logic of staying here on the condition that security was provided would be, well, that should be the position in line with the German court's position. If the German court in the end said, well, we've got nothing to do with this, the stay would then come to an end? The stay would become unconditional?
I suppose that is an order that could be made. I would have thought that it would be possible to simply apply for a stay then and say, well, the circumstances have changed. Now this is the basis of my application, but the German courts have just, if I were the appellant, obviously, now this is the basis of the new application for a stay, but the German courts have recently said they don't have jurisdiction.
Well, the alternative might be to place a rider, which is a permission to apply within 14 days of any decision by the German court or something like that.
Or that, yes.
So then what would cater for every eventuality? And you'd have 14 days to work out whether you wanted to come back.
That would cater for every eventuality. But of course, the position in Germany at present is that the 2003 judgment is enforceable, and we say there's no reason to say that enforceability here should be delayed by potentially quite a long time. I mean, I'm aware that the next hearing is listed for January, but it's already been adjourned on 2 occasions. I would not be 100% confident that jurisdiction will be resolved in January.
Well, you can get on with your new claim, can't you?
There is no new claim.
You're advancing a defence
Yes.
to Mr. Windhorst's application.
Precisely. So that doesn't create a new claim. What is being said instead is that it prevents the enforceability of the 2003 judgment being set aside, because that is something the court would actively have to do, and we say it can no longer actively do that because of the acknowledgements and part payments.
Well, in what forum would the acknowledgement argument be resolved? This involves both fact and law.
It would be resolved in Germany. So
On the 767 application?
yes, as part of a 767 application. So there is a bit here that in the BGH judgment that makes a difference between the trial court and the enforcement court. And we say the trial court is currently the OLG-Hamm. So that's the German court dealing with these arguments and with the questions of fact and with the intentions behind the payments, for instance.
Sorry, I don't understand that. How can it be the OLG? Because they're the appeal courts. Surely it's the LG.
Well, my understanding of the distinction between trial court and enforcement court is just the trial court is the court that deals with the substantive questions, and the enforcement court is dealing with enforcement itself. So I would say that as one body, essentially the German courts are the trial court, and the court that is dealing with the question in practice at the moment is the OLG-Hamm. And the enforcement court would be the English courts, because this is where enforcement is currently sought.
Sorry, I'm confused. It's not your fault. We're muddling up different questions. And you've helpfully given us your explanation as to what the BGH meant by trial court and enforcement. But let's come back to the proceedings which are currently pending in Germany. Are you saying that the hearing which was postponed from September to January is before the OLG? Because I would have assumed, unless I've got it completely wrong, that it would be back with the LG.
I thought it was with the OLG.
But why would that be? Because they've dealt with the appeal twice. Surely it goes back to first instance now. Because the first instance court's answer was simply to say, well, we've got no jurisdiction.
So my understanding is that in January, if that hearing goes ahead, the OLG will determine the jurisdiction question on appeal, because as I understand it, the only orders that have been made in this appeal so far in Germany were the 2 security orders. So those were interim orders rather than a determination of the appeal.
To be sure.
Yes, but I have someone behind me checking. Yes.
Right, okay.
So far it's just said, well, it's likely, the German court is likely to have jurisdiction. Come January, with a bit of luck, they'll decide whether they have jurisdiction or not.
Yes.
From our point of view, it's a pity the September hearing didn't go ahead, because we might have had an answer.
Yes.
All right, so okay, I think it was my fault. I misconceived it. So the issue but will they deal with any other issue? Suppose they decide that they do have jurisdiction, or the German courts have jurisdiction, to put it more accurately. Are they going to be dealing with anything else?
They will deal, the German courts in general will deal with the substantive question of the repayment acknowledgement defense. However, my lord, I cannot tell you whether that will be the Olgeham or the Bielefeld District Court. I don't know if, as a matter of procedure, it's going to be sent back to Bielefeld once the decision on enforcement has been made. The decision on jurisdiction has been made. But it will be the German courts determining it.
My experience of German procedure is that ping pong is quite common. So I would have thought it would go back.
It very much might, yes.
Yeah.
But yes, when it says here, these questions shouldn't be determined, and by that I mean the question whether Section 767 should apply to remove the enforceable nature of the judgment. When it says here that that has to be determined by the trial court rather than the enforcement court, we say that means it should be determined by the German courts rather than this court.
Yeah.
Now, of course, those are... I was going to make some introductory comments about the proceedings Mr. Windhorst commenced on the 18th of April 2019, but I think I can probably move a bit further down here. Yes, I mean, this might be helpful background. At page 194 of the supplementary bundle, this is an extract. This is an extract from one of the interim applications. This one was written by Mr. Levy's German lawyers. And this page in particular summarizes what is being said as a matter of substance in these Section 767 proceedings. Of particular importance here might be the last of the four points, which says that it's not being said that the acknowledgements and repayments give rise to any independent new claim, but rather that they preclude Mr. Windhorst from objecting to the enforcement of a judgment under his Section 767 claim. The next thing I would like to address is what the German courts have said about enforceability. There are 3 points here. The first is that they have supplied an enforceable copy, and that was relatively recent. If you go, my lords, to page 293 of the supplemental bundle. And you can see that that is the 4th enforceable copy of the judgment that's in the heading on the first page. And on page 298, at the end of it, it says the above copy is issued to the complainant for the 4th time for the purpose of execution after loss of the first 3 copies. So this was issued for the specific purpose of execution, and we can see that it was issued in April 2019, so 12 years after approval of the Insolvency Plan. Along similar lines, the German courts have issued an Annex 5 certificate, which is the documentation... Sorry, I should give you the reference.
I'm very sorry, what's the significance of this?
This is to show that the German courts regard the judgment as enforceable, notwithstanding the Insolvency Plan.
Thank you.
So pages 2...
Yes. I mean, how far does that go? I mean, I'm just wondering whether it is actually helpful, because presumably the court official thinks here's a judgment, why shouldn't it be enforceable? And at most, it could conceivably tell you something about grounds 2 and 3. It wouldn't say anything about ground 1. It would merely be about whether it was technically enforceable.
Right. The next point might also go towards ground 2 and 3 a bit more. Apologies, there is some overlap here. But that is, I take your point, my lord, about court officials, which is why we should, however, look at the decisions of the EWHC, where it ordered the security payment and where it confirmed security payment, because obviously that was a judge.
Sorry, you're about to show us the Annex 5 certificate, which I would find helpful.
Ah, yes, that is at page 25. So the translation is at page 253 to 254.
Thank you.
But what is probably more important are the orders of the Court of Appeal in Hamm, dated the 19th of February 2020 and the 27th of May 2020, because obviously this is a judge who knows exactly what has happened with the insolvency plan and who forms a view about what should happen with the enforcement of the 2003 judgment, at least for the time being. So the 19th of February one is at page 177. Here I can just refer to what Mr. Alatar has already said. It says that there will be a suspension of enforcement, but only against provision of a security. So in practice, enforcement can proceed unless that security is paid, and it's common ground that it's not been paid. And the other reference you might find useful, my lords, is on page 178, 1A, where it says in a preliminary assessment, the Senate affirms its international jurisdiction. So that is the February judgment, and then there was a short discussion going on about what the later judgment on page 204 is.
And just
Yes.
going to 1A on page 178, where they say it can initially remain open whether it's based on Article 24.5 of 1215/2012 or Article 22.5 of 44/2001. 1215/2012 is the replacement regulation.
Yeah, it's the recast.
Yes.
That's recast Brussels 1.
Yeah.
Yeah, so I wonder if they were unsure which one of the two would
Yes.
apply, because obviously
old
the judgment
judgment.
is old, but
Yes.
the 767 claim is relatively new.
Yeah.
But in any event,
But they're the same. I mean,
yes.
I mean, so why it matters is, I mean, of course, strictly speaking, you should identify which ratione temporis applies, but since the wording is the same, it doesn't matter.
No.
Exactly, and I think that's why they're saying they're leaving it open.
Yes.
And then on page 204, that was the later judgment of the same court after each party tried to vary the order. I cannot tell you the details exactly of each party's application, but I am aware that the respondent, for instance, tried to remove the security, the conditional stay, in favour of no stay at all, conditional or not. And then the appellant also tried to vary it in some way, and obviously both variations were, the court declined to vary the order in either one of those two ways.
Yes.
So that is the significance of that, showing that we're still in the same position in relation to enforcement and the security, and also to confirm that on page 205, paragraph 1A, the court confirms again that German courts are likely to have international jurisdiction. And it goes on to say that there's no need at this stage to determine the merits of the 767 defence that the respondent is trying to advance. So I take the point about court officials that in these two judgments there was a conscious decision not to order an unconditional stay, but only one that would kick in if a security payment was made. The thing that, of course, Mr. Alatar is contending is that all of that affects the English court's jurisdiction to grant a stay, and essentially imposes an obligation to grant a stay. Before Mrs. Justice Eady, the basis on which a stay was being sought was Rule 83.7.4 CPR. If, my lords, we could turn to that, it's at page 48 of the authorities bundle. That for you. My lords, I would invite you to just read 83.7.4. Not the commentary, I should say, but 83.7.4, the provision. So the key word we say is the court may, by order, stay the execution of a judgment or order. There's a discretion here, and it's important that there's a discretion here, because the English court must be able to take into account all matters that might be relevant to enforcement in England, and then to make up its mind in accordance with all the circumstances of the case. So Mrs. Justice Eady exercised her discretion and dealt with the point of paragraph 64 to 67. And she concluded at the end of paragraph 67 of her judgment that there were special circumstances, or there might well be said to be special circumstances, arising from all of this, the Insolvency Plan and the proceedings in Germany. But the fact that there were special circumstances arose from the choices made by the appellant, namely that he hadn't at any earlier point applied under Section 767 to the German courts, and also that he hadn't paid the security, even though he didn't say he was unable to do so. So on that ground, she found that it was not an expedient to allow enforcement of the 2003 judgment in Germany.
Sorry, just breaking those points down, I follow the point about failure to pay security. As to failure to apply earlier under 767, I don't imagine there was thought to be any need. It was only when you said you were going to try to enforce that the need to apply under 767 would have emerged.
Well, it is true that that warning only came in 2018. However, it came after Mr. Windhorst himself decided to make a €200,000 part payment. So that, in a way, was initiated by him. I take the point that perhaps...
I don't understand that. I understand that the payment of 200,000, and I put this entirely neutrally, gave you the opportunity to run the new argument. But is that to be held against him? That he should have, is it to be suggested that upon paying the 200,000 he should have thought, oh, Mr. Levy may come after me for the rest now, I better go off to the court?
Well, if he was concerned about his position, then that is a way in which he could have protected himself.
I mean, one of the things we don't know, it's quite clear that your clients, respective clients, have continued to have dealings with each other over 20 years-ish, since 2003. We can't make any assumptions about that sort of thing. I mean, there's no evidence about it, is there?
No, at least nothing that would enable this court to deal with it in any detail.
I mean, in a typical composition, say you have quite a number of creditors. Suppose you have, 20 creditors, and you conclude an insolvency plan which is approved. I can't believe the debtor typically initiates lots of 767 applications to stop the creditors enforcing. He just thinks, I've got a plan, the creditors take their 1.9% or whatever it is, and that's that.
Yes, you would presumably only do so if you thought that there might be some prospect of a creditor trying to enforce. We say that given the dealings the parties have had with each other and the part payments that were made, Mr. Windhorst might have had a reason to suspect that. However, I appreciate that's going a bit... I don't want to go beyond the scope of what this court can deal with. So in the circumstances, in any event, the choice not to pay the security was a choice that he freely made. If he had paid the security, then the order would not be enforceable in Germany. We say it's important to see that the provision expressly contains a discretion. It would be extremely unusual to say that the apologies for the laptop screen. I've got people instructing me in Germany, I'm afraid. But the point about the discretion is that it is in there expressly. So to say that an insolvency plan and the insolvency regulation can effectively turn that discretion into an obligation means that people would no longer know how the section applies by looking at it. And it would also raise the question, if the insolvency regulation and the insolvency plan means there's no longer a true discretion in this rule, what other factors would turn the discretion into an obligation? So we say that would introduce a very large amount of uncertainty, and that the better solution is, first of all, to determine whether the judgment is enforceable or not, and if it is, it can be registered, and then the English court has a true discretion, and it can take into account all kinds of circumstances when it exercises that discretion. So the existence of the insolvency plan is something that can be taken into account, but it doesn't compel the English court to order a stay. And we say that strikes a better balance, because an obligation obviously leaves no room at all for flexibility, while the discretion means that the purpose of the judgments regulation, the quick and easy enforcement and recognition of judgments in other countries, is preserved, while injustice to the debtor is also prevented. We also say that if the appeal is dismissed, then well, this might actually, but in any event, if the appeal is dismissed, then Mr. Windhorst can, if he succeeds in Germany, always apply for another stay. However,
only if circumstances change.
Yes, when the circumstances change. So it's not taking anything away from Mr. Windhorst if this application for a stay doesn't succeed, because if the circumstances change, then he can make a new application on that basis. So a stay shouldn't be ordered to preempt something that might happen in Germany.
But the effect of the ruling that you want us to make, if we make it today, is that you can execute tomorrow.
Yes.
So it may be a bit late when the German court finally gives its ruling.
Well, then there will probably, if we execute today and the German court gives a ruling that we weren't entitled to, or something along those lines, then surely the German court would also, or there could be an order, either here or in Germany, I suppose, reversing that execution, making us repay the money. I mean, judgments are set aside occasionally, and in those cases you also have to deal with what to do with any execution that might already have happened. But that's not a reason to say that execution of a judgment that at present is enforceable shouldn't take place. If there aren't any other questions on ground 1, I will turn to ground 2. So grounds 2 and 3 are obviously both about enforceability. Ground 1 asks the appellant, I should say, has to succeed, as I think is being accepted on the appellant's behalf, on both grounds 2 and 3, in order to succeed in relation to the registration order on this appeal. So
I hesitate to rise, my lord. That's not quite right. Grounds 2 and 3 are substantive. The acceptances as a gateway condition that's common. If I lost the gateway condition as to the exclusivity of 34 and 35, I probably lost on ground 2, and I probably lost on ground 3, although it is distinct, because it's an argument about what 38 means, just to clarify.
Yes, apologies. I hope I didn't mischaracterize that. But essentially, our understanding is that the appellant needs to succeed on ground 2 to convince you that Mrs. Justice Eady could have looked at enforceability and whether to grant the appeal in the High Court on that basis. And ground 3 says if she was able to look at it, should she have concluded that the judgment wasn't enforceable in the relevant sense. As my lords, you will be aware, Mrs. Justice Eady didn't determine the point with which ground 2 is concerned because she took the view that she didn't need to, given that she came to the view that the judgment was enforceable in Germany. Just to briefly explain what conflict there is here, there's Percival and Motu on the one side, which relies on the comments of Professor Briggs, on which my learned friend has addressed you briefly at the end of his submissions. And there it is said that Articles 34 and 35, together with Article 45, cannot be read literally in the sense that the court really cannot look at anything else other than the list of factors in 34 and 35 as objections to a registration appeal. It is even, I believe Professor Briggs goes so far as to say any objection can be taken at the stage of a registration appeal so long as it doesn't attack or challenge the substance of a judgment, because of course Article 36 precludes that. In the Percival case, that is a point I should make at this stage, only one of 3 judgments, so 3 judgments were registered, and it was held on appeal that only one of the 3 judgments should have been registered, but that was also the only judgment in relation to which there was an Annex 5 certificate. So that was the view taken in Percival, and then we've got some European cases which say, first of all, that the list of objections should be read restrictively, and also that they are exhaustive in nature. So first of these is Prism Investments, paragraph 33 on page 168 of the authorities bundle. I believe my learned friend took you to that earlier as well.
Yeah.
So we agree with my lord, your Lord Justice Arnold's observation that this contains 2 different statements. The first is restrictive interpretation, and that is to be found in Apostolides and Orums, and then that's developed further to say the list is exhaustive in nature. And we say that is part of the ratio of that case, because at least one important reason why payment of the debt or satisfaction by way of a settlement agreement couldn't be taken into account was that it wasn't one of the factors in 34 and 35. It was said by my learned friend that if that had been the ratio of the case, then the judgment could have simply ended after paragraph 33. We say it would have still been coherent if it had ended there, but of course the European Court of Justice is meant to give guidance and also to explain its reasoning behind certain statements. So simply saying it's exhaustive in nature and not explaining anything would probably have been relatively poor guidance. Well, here we can actually see why it's saying that it would be a problem if you took into account those complex matters such as whether all the conditions under the settlement agreement were met in a registration appeal, because it would make the procedure a lot more complicated, it would make the procedure take longer, and it wouldn't be in line with the goals of the judgment's regulation. Then the same thing is said in Salzgitter Mannesmann-Handel GmbH at paragraph 28, that is at page 198 of the authorities bundle. So there it is also said that the list of objections is exhaustive in nature. And we say once again that was an important finding in that case, because the background of the case was that a Romanian company had brought a claim in the Romanian courts. That was dismissed. It then brought the same claim, basically, so a claim on the same ground of action in the same court, and the defendant to that claim inadvertently didn't attend, and then a default judgment was entered. And one can see why a debtor might take objection to that type of judgment being registered, because obviously it doesn't look right, and most legal systems won't allow you to simply bring the same claim several times. But it was said there, the list of objections is exhaustive, so this can only succeed if it's within Article 34.4, which is one of the potential objections, and that is inconsistent judgments in different member states. And then it was said, well, these are inconsistent judgments in the same member state, so it doesn't fit within 34.4. And the registration stood.
Yeah,
So-
but as I understand it, you're particularly in support of that submission relying upon what they say at 39, where they say since it's exhaustive, you can't apply by analogy.
Precisely. So we say both that and the prison decision are actually decisions that do have as part of their ratio the statement that the grounds of objection in 34 and 35 are exhaustive.
Is there a distinction to be drawn between points being raised which go to the question whether a judgment falls within the regulation at all, and points being raised, which is what's contemplated by 34 and 35, which are objections to the judgment? Does that work?
It seems that there would have to be some matters of English procedural law if a registration application were to be raised in England, that would affect. So, for instance, there are some decisions where the courts have decided whether the applicant is an interested party. In the same way, if I file a Chinese judgment and say I want this to be recognised under the judgments regulation, then it must be open to the court to say, oh, well, that's not a member state, a judgment from a member state. But we say there's a division of labour here, and those things are things that an English court can always determine when it's got an application in front of it, to essentially say, is this the jurisdiction that we're being asked to apply here? Does this person have standing? Is this the right type of application? Enforceability, however, we say is very different, because the regulation itself assumes that and it prescribes that the courts in the country of origin will tell the courts in the country in which enforcement is sought whether the judgment is enforceable. And we can see that at Article 54 of the Judgments Regulation at page 32 of the Authorities Bundle.
Yes, and normally the certificate will be conclusive, but it doesn't. The regulation doesn't actually say that the certificate is to be conclusive and binding in all circumstances.
No,
It simply lays down the level of evidence upon which reciprocal courts will operate.
It doesn't specifically say that. However, we say that if you take into account the mutual trust principle, which is mentioned twice, I believe, in the recitals to the Judgments Regulation and also in recital 22 to the Insolvency Regulation, then one cannot go behind an Annex 5 certificate, because doing so would be for instance, an English court to say that the German court is wrong in thinking its own judgment is enforceable. And we say that wouldn't be consistent with the purposes of the Judgments Regulation.
Sorry. I mean, for your purposes, there are two stages. Potentially, you say, well, Professor Briggs is just wrong. A fallback position is to say, well, okay, there are some perimeter questions that could be looked into. But as you say, that doesn't mean you can look into enforceability, and in particular, we know from PRISM you can't look into whether a debt has been satisfied. If you can't look into whether a debt has been satisfied, why should you be able to look into whether there's been a composition?
Yes. So, sorry, I'm not quite sure what.
Yeah, sorry. PRISM says that at the enforceability stage, you can't look into whether the debt has been paid, as I understand it.
Yes.
So even supposing that the court, considering enforceability, can look at some perimeter questions, it isn't entitled to look at whether the debt has been paid.
Yes.
And I suppose for your purposes, you say, well, if you can't look at whether a debt's been paid, you can't look at whether it's being compounded either.
Precisely. Although, of course, we would say that you need something from the court in the country of origin showing you that the debt is enforceable, and quite often composition will affect that. So, for instance, it seems that in France, I take that from Eric Corsier, it seems that in France it just extinguishes judgments. I mean, obviously I'm not an authority on French law, but
Yes.
if it actually has that effect in a legal system, then the idea is that the court in the country of origin could no longer confirm that the judgment is enforceable. But we say this is a question on which the court in the country in which registration is sought has to be able to rely on what the court in the country of origin is saying. Because if it cannot, then this also gives rise to a large amount of uncertainty. For instance, if we don't think that there's this is all about formal enforceability, and if we thought there was some kind of different concept of enforceability, an autonomous principle, then we would actually need some kind of definition. And it's probably quite difficult to find a definition of enforceability that is not tied to the procedural systems of the country in which the relevant judgment originated. So that is why we say it might be that there are some points outside of Articles 34 and 35 that a court can look at. We say those would only be points that are in the procedural sphere of the court that is hearing the registration application, because it has certain powers to look at any kind of application before it for things like standing. But we say that enforceability is firmly within the sphere of the country of origin. So it's the country of origin that would be expected to have the answer to that question. And of course, we also don't want the risk of inconsistent judgments between the country of origin and the country in which registration is sought. I should say there have been, in La Caisse Régionale de Crédit Agricole Nord de France and Ashdown, tab 11 of the authorities bundle, there was some discussion of enforceability, but that arose in a context where it became clear that the judgment had simply been mistranslated. So the French judgment said fixe rather than condamne. Sorry for my pronunciation there. And that meant it only fixed the sum due rather than actually ordering someone to pay that. And we say there's actually no difficulty with correcting that kind of mistake, because the principle is that one should be able to look at the foreign judgment and look at the Annex 5 certificate or whatever other equivalent the foreign court might have provided and say, I can see that this is enforceable, and that would give rise to some certainty. My lords, may I move on to ground 3, or are there any queries about this?
Move on.
So, you've already heard my submissions on the German Federal Supreme Court judgment, so I won't go over that again, but essentially its ratio was that unless and until a Section 767 claim is granted, the enforceability of a judgment remains in place. We also say that it's clear from the wording of Article 38 of the Judgments Regulation but the question to be applied is what the position under German law is, rather than what the position under any other international principles might be, because it says a judgment given in a member state and enforceable in that state. So it's also clear that this is all about formal enforceability only. The European Court in Eric Corsier made some comments about this. Well, I might take you to that briefly at page 86 of the authorities bundle, at paragraph 24. And that was an early expression of that principle that later came to be applied in prison investments, that objections such as the debt has been paid do not stand in the way of formal enforceability. I'll now take you, my lords, through four...
At that stage, had not the Advocate General thought that you could take into account payment?
Yes, I think the Advocate General made a comment to that
15.
effect. That was then not adopted in the judgment. And of course now we have prison investments,
Yes.
which makes quite clear that even if that was once potentially thought to be the position, it definitely isn't now.
Yes.
My lords, I would like to take you through 4 categories of cases now. And that is basically the last thing I'm doing, where judgments have been registered despite what might be perceived as some obstacles to that. Firstly, provisionally enforceable judgments. Secondly, judgments that may be incapable of enforcement for practical reasons. Thirdly, judgments that are inconsistent with other judgments in the country of origin. And finally, judgments in respect of which one side says the debt has been settled or compromised. So, provisionally enforceable judgments, there are 2 cases here. One where a comment is made about it, but I think it's a helpful illustration, and one where the actual case was about it. So, to come to that first comment, if you go to page 112, my lords, that is the Advocate General's opinion in Orams and Apostolides. And the part that we say is particularly important is the end of paragraph 97. The last sentence of that: formal enforceability is lacking if an appeal has been lodged against or still lies from the judgment and the judgment has not been declared provisionally enforceable. So that observation means if a judgment is provisionally enforceable, then even if an appeal is outstanding, or there's some other reason to think it might be set aside in the future, it is liable to be registered.
Can you say that once more?
Yes. So it says here a formal enforceability. It says here there's no formal enforceability if there's an appeal outstanding, or it's still possible to appeal, and the judgment hasn't been declared provisionally enforceable. So a judgment that is provisionally enforceable until the appeal must therefore have that quality of formal enforceability. It might be helpful if we
That's
go
too subtle for me.
Yes, there is a different case that makes the point a bit more expressly. So if we go to tab 10, that is the case of Normaco Limited and Lundman. if I could invite you to read paragraphs 5 and 6 of that decision. So there's no requirement here, and it is said that a judgment has to be final and conclusive for these purposes. And because of that, it is said at paragraph 9 on the next page that therefore a Mariva injunction, a freezing injunction, is in principle one which can be certified, or as we would now say, registered, so long as it was made inter partes, and where the defendant has had an opportunity to resist it. And of course, the nature of freezing injunctions is that they tend to be discharged at some point. So we say that and the comment in Apostolides together show that provisionally enforceable judgments are covered and can be registered under this regime. Then judgments that are incapable of enforcement for practical reasons, that I won't have to address in great detail because Mr. Alatar has already, I believe, set out the background to this case. The one I'm referring to is Apostolides. The judgment at paragraph 70 to 71 on page 129 confirms the relevant point. So this was about the land in the northern part of Cyprus, where the judgment couldn't be enforced using the Cypriot government because it didn't actually have any control in that part of the country. But as you can see from the judgment, that type of practical problem did not stand in the way of registration. And thirdly, judgments inconsistent with other judgments in the same member state. That is the judgment I took you to earlier, Salzgitter minus 100 GmbH, about the two Romanian judgments that were not consistent with each other. And as I've said earlier already, because that wasn't one of the objections in Articles 34 and 35, and because Article 34.4 wasn't wide enough to deal with this type of situation, the registration order also remained in force. The most important and final of the four categories we say is the one Prism Investments and Vandermeer from page 161 and tab 7, where, as has already been set out previously, it was a Belgian judgment arising from a loan. It was registered in the Netherlands, and then the judgment debtor objected and said the debt was no longer payable because it had been settled in Belgium. And, my lords, it would be helpful if we could look at paragraph 47 on page 180 for a moment. That is the Advocate General's opinion. And I'll let you read that for a moment.
Paragraph.
47.
Thank you.
Those concerns that are set out here are echoed at paragraph 35 of the judgment. It essentially says the same thing, but it's shorter, so I'll just give you the reference. It's on page 168, paragraph 35. So that concern, we say, very much applies in cases like the present as well, because here we also have something that happened after the judgment that one side is saying should mean the debt is no longer due, and the other side is saying does not, because of the acknowledgement of part payments, affect the respondent's rights, at least not as the position is at present. And the German courts have been deciding this for a very long time. So this is precisely the type of complicated thing that you would not wish to introduce routinely into registration appeals.
I mean, the only thing about that is that I don't imagine you get this sort of argument very often with compositions. Normally, if a debtor felt the need to apply under 767, it would be very routine, I imagine. Normally, the creditor wouldn't be able to say anything other than, oh, okay, I've agreed to take 1.9% or whatever it is.
Yes, so there will be a lot of cases where it is in fact straightforward, just as payment will be in a lot of cases straightforward. If you can just show someone bank statements and say, here you go, I transferred $3 million, then of course there shouldn't be any big dispute about that. But just as with payment and settlement agreements, it can become complicated. And in the event that it does, it's something that needs to be determined by the courts who are seized of, the courts of origin of the judgment, basically. Yes, so that point is made at page 168 of the judgment in Prison Investments at paragraph 40, that such a ground may, by contrast, be brought before the court or tribunal responsible for enforcement in the member state in which enforcement is sought. So it cannot be a question that the English court can decide when it decides registration. It is, of course, a factor it can take into account when it exercises its discretion and has to decide whether to order a stay. But as we said earlier, that is a true discretion which Mrs. Justice Eady exercised properly, and there's no obligation in relation to that. So we say the compromise of the debt in Prism Investments is really very similar to what is being said in the present case, because in Prism Investments it was being said the creditor essentially waived his right to enforce or to claim this debt because of the settlement agreement, and here it's being said that the creditor waived his right to claim the debt because of the insolvency.
Well, so the difference is the insolvency is based upon a court decision.
It is, but the question is whether that should actually make any difference, because one could also think of, for instance, a Tomlin order that is approved by a court. Would that? We submit that that wouldn't make a difference whether it's a normal settlement agreement or a settlement agreement that has been approved by a court, and therefore we say that the insolvency plan also shouldn't be treated differently just because it's been approved by a court. And secondly, we know from the decision of the Federal Court of Justice in Germany that the insolvency plan didn't deprive the judgment of its enforceable nature. And that, of course, is confirmed by the recent decisions of the OLG, which says enforcement will be suspended under certain conditions. If a judgment isn't enforceable, you don't have to make any orders saying it will be that enforcement will be suspended if certain conditions are met.
I'm sorry, I thought you were talking about Mrs. Justice Eady's exercise of her discretion, which is a very different question from whether or not the original judgment is still enforceable.
Well, we say the way these things fit together in this case is that once the enforceability decision has been made, then the court has a discretion to decide what should happen to enforcement. So apologies if perhaps I was conflating the two a bit. But we would say in conclusion that this appeal should be dismissed. The three grounds in short, we address as follows: that the English courts should not carry out, that's ground two, the English courts should not carry out their own review of enforceability, because there is an Annex 5 certificate in this case, and it's clear from the judgment it's not purely declaratory, and we say in those circumstances the English court could not go behind that. But we also say in any event, on ground three, if the English courts did carry out their own review, as Mrs. Justice Eady did, then they would have, then any reasonable judge, as Mrs. Justice Eady did, would have concluded that under German law, and that is the relevant test, the 2003 judgment was enforceable and therefore could be registered. And then thirdly, we say that Mrs. Justice Eady had a discretion and could decide freely whether or not to order a stay, and that there was no obligation on her part to do so. So we say, in essence, that here the judgment should be treated in the same way that it's currently being treated in Germany, where it is today enforceable and will remain enforceable until either a security is paid or Mr. Windhorst's claim succeeds. And we say that treating it in any different way would give rise to uncertainty and complexity, and therefore delay and cost if other cases followed that model in the future. It also means a debtor could strategically decide where to place his assets, because, for instance, they'd be safe from enforcement in England, but not in Germany, and that is what the regulations were meant to avoid. And unless I can assist the court any further, those are my submissions.
Thank you very much, Ms. Flanagan. Mr. Arnold.
My lords, very briefly, I think I've got 5 points that I'd like to raise. The first is just to highlight something that I mentioned earlier in my learned friend skeleton argument. It's paragraph 44 of a written submission. Page 46 of the core bundle, my lords. Reasons already set out above in section B. Neither the Insolvency Plan nor the Insolvency Regulator had, in German procedural law, the effect of rendering the judgment unenforceable. The reference to section B above is a reference most pertinently on page 40 to paragraph 18. And following. I won't read all of it. The judgment is concerned with the procedural position in Germany following a residual...
Sorry, where are you reading from?
Paragraph 18, third line. The judgment in that sentence is referring to the Bundesgerichtshof judgment. And then the second part is the fourth sentence. The respondent accepts that this decision accurately represents the procedural position under German law. I don't need to turn up that decision again. I've read you paragraph 11. And ignoring all terminology about trial courts, enforcement courts, I've emphasised that the important point there is the distinction between substantive obligations and a substantive defence to the obligation. That's the effect of the composition. In that case, it's an English bankruptcy discharge. And the first of my 5 points is that my learned friend's submissions on ground 1 do not give true effect to Article 25 of the Insolvency Regulation. That regulation, we don't need to turn it up, I think, says compositions approved by the court shall also be recognised with no further formalities. There's nothing further that this court should do to give effect to a composition. It's a judgment, not in a novel form of judgment that we get in civil disputes where there's a claimant and defendant, but it is a judgment, the effect of which affects a substantive debt obligation antecedent to the composition. And Article 4 tells us that it governs the effect on that obligation and the effect after closure. That's to be given effect to with no further formalities. That is the basic point. I don't need to repeat my submissions that flow from it. What I do want to address is the second point, is the issue of security. I've already addressed Lord Justice Newey's question as to why this court essentially shouldn't order security. I maintain those submissions, but I want to emphasise that if you test it in an extreme case, if a foreign debtor has a debt discharge under bankruptcy, take an Irish bankruptcy, and a judgment creditor prior to the bankruptcy seeks to execute against their property in England, and the judgment debtor relies on the bankruptcy discharge as the defence, it would be contradictory to Article 25 and Article 17 for this court to impose a security requirement. That would be imposing a substantive fine on giving effect to the discharge. The same is true with respect to the composition in this case. That's why we've maintained a purist case below and on appeal, that it wouldn't be right to impose a security condition because that's not giving effect to the composition. That's what I wanted to say in the second point. The third point is a relatively short point, and it concerns the document you were taken to at page 298 of the supplemental manual. This was the short one sentence, "We've reissued this judgment for a fourth time, quote, for the purpose of execution." My Lord Justice Newey alighted on the point, which is, isn't this just a court official issuing a document? I wanted to show you one brief document in the supplementary bundle, and that is the letter of the 17th of September. We haven't looked at it. It's at page 105 of the bundle. If you have time and inclination when writing your judgments, my lords, it's an interesting letter.
Sorry, which page are we on? 105.
Well, it starts at 104,
104.
so you can see the title to it. Tank is the name of the law firm, so it's the Vexon. This is Mr. Levy's law firm. And I say it's a slightly unusual letter because it's effectively a letter before action. And it starts off with praising the lawyer, says he's followed Mr. Windhorst's career and so on. But he then goes out to outline the strategy that is now being played out in this litigation. And you see it at page 105 in paragraph 2. The insolvency plan procedure before the local court does not alter this suitability of the judicial title, it being the order, since the enforcement bodies would not even examine the content of the title submitted from Bielefeld. So we don't know what happened in this case as to why the judgments had to be reissued 4 times, but we know this is the 4th reissue of the judgment, and as my Lord Justice Newey indicated, it appears to have been issued as a matter of an official request is submitted, an official produces a copy of the judgment. That's how that document was obtained. And that was the third point. The fourth point concerns the submission made in relation to the CPR. It relates to my learned friend's written submissions at paragraph 22 of her skeleton document, where she says, and in my submission rightly, that execution is entirely governed by English law. The mistake is to read English law too narrowly. English law includes the insolvency regulation. There is no conflict between the insolvency regulation and the word may in the relevant CPR provision. Of course the court has a discretion, but it does not exercise that discretion in a vacuum. If one thinks about it, the insolvency regulation is right at the top of our hierarchy of norms. The CPR rule is actually a provision of subordinate legislation. It's not inconsistent with the discretion under the subordinate legislation to, when one exercises that discretion, to have regards to other obligations binding upon the court. And in this case, my submission is that Article 25 and the obligation to give effect to the composition is an obligation that, in this case, impels the exercise of the discretion. The exercise of discretion being impelled on the facts of this case does not mean the discretion is being overridden and that somehow there's some impermissible conflict with the CPR. Finally, my lords, moving on to ground 2, I had very little to say on ground 3. I wanted to address my Lord Justice Newey's question as to taking the two-stage analysis, is there a perimeter question? And essentially, is this one of them? Why should you be able to look behind the composition? I've given you the short answers already, which is that it is a judgment. It is effective throughout the community and therefore qualitatively different from the compositional payment cases at issue in prison. I've already taken you to the Advocate General, who says the question was left open, and the court, in my submission, does not appear to have addressed that question or closed upon the facts of that case. What I want to end on is a submission I didn't quite develop as fully as I would have liked, which is this a kind of perimeter question? And Article 67 says that the judgments regulation should not conflict with other community legislation. Article 71 is the same in relation to treaties. In my submission, it is the same perimeter question, because what we have here is a judgment that is a composition, and there would be a conflict with it, perhaps not in name, but certainly in substance, if that composition were not given effect to and a judgment were entered, notwithstanding that judgment had been compromised 2 years after it was given in 2003. And that's the jurisprudence I'm asking you to develop. You don't get much help from it from the ECJ, but the policy reasons I would suggest do support it, because none of the difficulties in prison arise in this case. If the difficulties in this case arise, it's no more than the same difficulty as this court and the courts below would face in any case where one has a foreign bankruptcy discharge or a foreign liquidation or anything of that sort. One is simply recognising the effects of a foreign order, albeit one that doesn't look like the more familiar in personam money order. Can I just take some very brief instructions, please? My lord, there's nothing else unless I can assist you.
In which case, thank you very much. So thank you, both of you, very much for your clear and relatively concise submissions coming in on time. We'll reserve our judgments. As you'd expect, they'll be provided to you in draft for you to correct our typing and grammar and such like things, but not to re-argue the case. I think that judgment will in all probability be remote, but even were the judgments to be handed down in court, there would be no need for anyone to attend. As you'd expect, we'd be grateful if in advance of the judgments being handed down, you'd seek to agree an order dealing with consequential matters. If there are any points on which you differ, could we please have brief written submissions, and we'd expect to determine the points by the order that we make. But thank you both again.